The call came on a Thursday. My attorney's voice was strange, clipped, the way it gets when he's choosing every word carefully. "Horace, we have a problem. Your son filed the paperwork this morning. He's liquidating the lake house using the power of attorney you signed. I was 3 days out of surgery, still tethered to a hospital bed by wires and tubes, but I was awake, and I was not the same man who'd signed that document. 6 months earlier, I'd sat in this same attorney's office and updated my will. The documents my son was relying on had been superseded. They just didn't know it yet." This is Harlan Webb, 74, retired cardiothoracic surgeon, and the lake house he'd spent 30 summers building on the shores of Coeur d'Alene. His son Derek held a durable power of attorney, signed during a health scare 2 years earlier, and now Derek was using it to liquidate the property while Harlan lay in a hospital bed, recovering from quadruple bypass surgery. But what Derek didn't know, what nobody in the family knew, was that 6 months before the surgery, Harlan had walked into his attorney's office and executed a new will, one that explicitly revoked all prior powers of attorney and named a professional trustee. Derek was racing toward a closing on a sale that was already legally void. The only question was whether Harlan could stop him before the ink dried. To understand what was about to happen, you have to understand what that lake house represented. Harlan Webb had purchased that land in 1989, 6 acres of pristine shoreline on Lake Coeur d'Alene. At the time, it was raw forest. No road, no power, no dock, just water and pines, and the kind of silence that made you remember what quiet actually sounded like. He built the main cabin himself over 3 summers. Every beam, every window frame, every stone on the fireplace came through his hands. His wife Alina was alive then. She'd sit on a folding chair by the water, reading paperback novels while Harlan hammered and sawed and sweated through July afternoons. They'd swim at dusk, cook dinner on a camp stove, sleep with the windows open, and wake to loons calling across the glass-flat water. Alina died in 2008, pancreatic cancer, 6 months from diagnosis to funeral. After she was gone, the lake house became something more than a summer retreat. It became the place where Harlan still felt her presence. Her books were still on the shelves. Her garden, overgrown now but still blooming with the perennials she'd planted, still came back every spring. The dock they'd built together, weathered silver by 30 winters, still held the imprint of their summers. Harlan had 2 children, Derek, the older by 4 years, and Melissa, who lived in Seattle with her husband and 2 kids, Harlan's only grandchildren. The family dynamic had shifted after Alina's death. Derek had always been the one who needed more attention, more money, more second chances. Melissa had been the one who built her own life, called every Sunday, visited when she could, never asked for anything. But here's what matters. 2 years before the surgery, Harlan had a health scare, a minor stroke, brief. He recovered fully within weeks, but during that window of vulnerability, Derek had stepped in, got his father to sign a durable power of attorney. Standard document, Derek had said, just in case something happens, just so someone can pay your bills if you're incapacitated. Harlan signed it. He trusted his son. That was his first mistake. The durable power of attorney gave Derek broad authority. Too broad, as it turned out. Under Arizona law and Idaho law, where the lake house was located, a durable POA becomes effective immediately upon signing and remains in effect even if the principal becomes incapacitated. No court oversight. No requirement to report transactions to anyone. No check on the agent's decisions except the agent's own conscience. Harlan didn't think about it again. The document went into a filing cabinet. Life continued. He split his time between Phoenix and the lake house, still practicing medicine part-time, still active, still sharp. Then, 6 months before the surgery, something changed. Harlan never told anyone exactly what prompted it. Maybe it was a conversation he overheard. Maybe it was a pattern of small things, Derek asking about finances more frequently, Derek showing up at the lake house with a real estate agent in tow, pretending it was casual. Maybe it was just intuition. 40 years as a cardiothoracic surgeon had taught Harlan to read subtle signals before they became emergencies. Whatever the trigger, Harlan made an appointment with Robert Chen, an estate attorney in Coeur d'Alene, not his regular attorney in Phoenix, a specialist in Idaho property law. He spent 4 hours in Chen's office, reviewing every document, every account, every asset. And when he walked out, he'd executed a new will, one that explicitly revoked all prior powers of attorney, one that named a professional fiduciary as trustee, one that made it impossible, legally impossible, for anyone to liquidate his assets without his direct, competent consent. He filed the documents, locked the originals in a safety deposit box, told no one, not Derek, not Melissa, not even his business manager. He knew what he was doing. He'd seen families torn apart by inheritance disputes. He'd watched colleagues lose everything to greedy children. He understood that the most dangerous threat to an estate isn't always a stranger, it's often someone with a key to the front door. The quadruple bypass was scheduled in Phoenix. Routine, the surgeons said. Elective, he'd be in the hospital for 5 days, then home recovering. Derek flew in from Portland. Helpful, concerned, the attentive son. He drove Harlan to the hospital, sat with him in pre-op, held his hand while the anesthesiologist did her work. And the moment Harlan went under, Derek activated the power of attorney. The timing was not a coincidence. Derek had been waiting for this. The durable POA gave him authority to act on his father's behalf, and with Harlan under anesthesia, intubated, incapable of monitoring or questioning anything, Derek had a clear field. Within 48 hours of the surgery, Derek contacted a real estate brokerage in Coeur d'Alene, listed the lake house for $1.2 million, significantly below market value, cash sale preferred, quick close required. Within 72 hours, he'd found a buyer, an investment group out of California. They'd been watching lakefront properties in Idaho for years, waiting for a distressed sale. Derek's listing looked exactly like what they wanted: motivated seller, below market price, fast close. They made an offer, full asking price, cash, 10-day close. Derek signed the purchase agreement on his father's behalf, used the power of attorney to open escrow, provided the title company with a copy of the POA document, the 2-year-old version, the one that was no longer valid, the one that had been explicitly superseded by the will Harlan filed 6 months before. The title company didn't catch it. They ran standard checks. The POA appeared legitimate on its face. They had no reason to search for a more recent revocation unless someone told them to. Derek was 48 hours from closing, 48 hours from wiring $1.2 million into an account he controlled. And Harlan was still in the hospital, day 3 of recovery, drifting in and out of consciousness, surrounded by beeping monitors and IV drips, completely unaware that his son was selling his wife's lake house out from under him. But here's the thing about Harlan Webb. He hadn't survived 40 years of cracking open chests and restarting hearts by being careless. He'd built his career on anticipating every possible complication before the first incision. And 6 months ago, sitting in Robert Chen's office with a view of the same lake his wife had loved, he'd anticipated this one too. The documents Derek was relying on, the power of attorney, the legal authority, the whole framework of his plan were already dead, superseded, revoked, filed and witnessed and legally binding. The only thing that mattered now was whether Harlan could wake up, reach a phone, and stop the closing before the money transferred. Because once those funds hit escrow, the legal fight would shift from prevention to recovery, and recovering wrongfully transferred property from an investment group with deep legal pockets was a nightmare Harlan didn't intend to survive. 3 days out of surgery, wires in his chest, tubes in his throat, and somewhere in Coeur d'Alene, a title company was preparing final documents for a sale that would either destroy his legacy or become the evidence that destroyed his son. The call from his attorney came at 9 in the morning. Derek filed the paperwork today. He's liquidating the lake house. And Harlan, still tethered to that hospital bed, still barely able to speak, whispered 3 words into the phone. "Get me Chen." Robert Chen answered on the second ring. I could hear him reaching for a pen, the scrape of chair legs on hardwood, the shift from ordinary Tuesday morning into something else entirely. "Harlan, you sound terrible. I didn't have the breath for small talk. Derek filed this morning. He's selling the lake house, using the power of attorney." A pause. Then Chen's voice dropped into the register I'd heard him use in court depositions. Calm, precise, dangerous. that power of attorney is void. We revoked it explicitly in the new will. Your son is attempting to sell a property he has no legal right to touch. The words landed somewhere deep in my chest, somewhere past the surgical incisions and the morphine haze. My son was not just betraying me, he was breaking the law. I told Chen the timeline. Derek had the power of attorney from 2 years ago, the one I'd signed after my stroke, the one that gave him broad authority without oversight. He'd presented it to a title company in Coeur d'Alene. They'd accepted it. Escrow was open, closing scheduled in 48 hours. Chen didn't hesitate. I'll kill the closing, right now. Give me the title company's information. I'll fax them the revocation documents, the new will, the superseding language. They cannot legally proceed. They won't want to proceed. I'll also notify them that any attempted transfer is void, and if they close after receiving our notice, their errors and omissions insurance is going to have a very bad year. I gave him what I had, the text from my Phoenix attorney, the name of the brokerage, the brief window of time before $1.2 million moved from a buyer's account into my son's hands. Chen hung up to start the calls. I lay back against the hospital pillows, the ceiling tiles swimming in my vision. Elena's lake house, the dock, the loons. Derek had tried to liquidate it while I was unconscious. I'd known my son was ambitious. I hadn't known he was capable of this. But here's where the story deepens, because Derek Webb wasn't some cartoon villain twirling a mustache. He was 46 years old, a father himself, 2 kids, a wife named Julia who'd always seemed kind. He'd worked in commercial real estate in Portland, a respectable career, though I'd heard whispers about troubles, deals that fell apart, partners who'd been burned. His lifestyle exceeded his visible income, but families help each other. That's what I'd always believed. What I didn't know, what I was about to learn, was that Derek had been bleeding money for years. A failed development project in Bend had left him personally liable for $700,000 in construction loans. He'd borrowed against his house, emptied his retirement accounts, maxed out credit lines. 3 months before my surgery, he'd taken out a hard money loan at 22% interest from a private lender in Boise. The kind of loan you only take when every bank has already said no. The lake house wasn't just opportunistic greed, it was a lifeline. Derek was drowning, and he'd convinced himself that my property was his escape hatch. His reasoning, as I later reconstructed it from text messages and emails recovered by my attorneys, went like this: Dad is 74, he's having heart surgery. If he survives, I'll deal with the fallout later. He'll forgive me, he always does. If he doesn't survive, I'm the executor. I control everything. Either way, the lake house is mine. He hadn't counted on Robert Chen. Chen faxed the revocation to the title company at 10:15 that morning. The document was 8 pages. The new will, properly witnessed and notarized, dated 6 months prior. The explicit clause, all prior powers of attorney, including but not limited to the durable power of attorney executed on March 14, 2022, are hereby revoked and superseded by this instrument. The signature was mine. The notary stamp was clear. The legal effect was absolute. At 10:47, the title company's senior escrow officer called Chen back. Her name was Patricia Morrow. She'd been in the business 22 years, and she'd never seen anything quite like this. The buyer's funds were already wired in. The closing documents were prepared. Derek Webb was scheduled to sign the final transfer papers at 2 o'clock that afternoon. He'd been calling her office every hour, pushing to accelerate the timeline. Now she understood why. Chen explained the situation in terms she couldn't ignore. If your company closes on a property transfer executed under a revoked power of attorney, you're facilitating a fraudulent conveyance. The title insurance policy will be void. Your company will be liable to the buyer, to the seller, and possibly to the state of Idaho. Patricia Morrow put the file on hold immediately. The closing was suspended, pending legal review. And then the phone calls began. Derek was in a Starbucks in downtown Coeur d'Alene, killing time before the 2 o'clock appointment, when Patricia's assistant called to tell him the closing was delayed. No explanation, just due diligence issues. Derek's response was immediate and volcanic. He demanded to speak to the escrow officer. When Patricia got on the line and mentioned questions about the validity of the power of attorney, Derek erupted. This is a valid document. My father signed it. I have every right. You can't just delay this without grounds. Patricia remained professional. Mr. Webb, we've received documentation from your father's attorney suggesting the POA has been revoked. We cannot proceed until we verify the chain of authority. This is standard practice. Standard practice. Those two words sent Derek spiraling. He hung up and called my hospital room. I saw his name flash on my phone, ignored it. He called again and again. Then the text started. Dad, what are you doing? The real estate deal is good for everyone. The property needs too much work for you to manage alone. I'm helping you. Why are you trying to interfere? Helping me. Every message I read widened the hole that had opened in my chest, the one the surgeons hadn't fixed. Helping me by selling Elena's lake house while I was on a ventilator. Helping me by pocketing the proceeds of a lifetime's labor and memory. I let the calls go to voicemail. I let the texts stack up unread. Then I called my daughter Melissa in Seattle. She needed to know, not for permission, for warning. Because when Derek realized the closing was blocked, he would panic. And panicked men do things that ripple outward. Melissa answered on the first ring. Dad, you should be resting. I told her everything. The POA, the listing, the closing, the revocation, the title company's freeze. There was a long silence. Then Melissa said something that changed the shape of the story. Dad, there's more about Derek, about what he did after your stroke. After the stroke 2 years ago. My hand tightened on the phone. Tell me. Melissa's voice was tight, controlled, the voice of someone who'd been carrying a secret too long. After your stroke, Derek asked me to sign papers. He said you needed the lake house in a trust for tax reasons. He wanted me to transfer my future interest in the property to a trust he controlled. I didn't sign, I didn't understand it, but he pushed hard, really hard. And when I pushed back, he told me I was being selfish, that I didn't understand how estate planning worked, that I was putting your legacy at risk. The ceiling tiles swam again. Derek hadn't just acted after this surgery. He'd been planning this since my stroke. The POA was never about paying my bills. It was about control. He'd tried to get Melissa on board, tried to lock up the lake house through a trust structure that would have cut her out entirely. When she refused, he'd waited 2 years, waiting for the next medical event, the next window of incapacity. The quadruple bypass was his opportunity, but the plan had been alive for 24 months. Melissa, I said, I need you to document everything, every conversation, every email, every text. My attorneys will want it. She was already ahead of me. I saved them, Dad, all of them. I knew something was wrong. I just didn't know how to tell you without sounding like I was turning against my own brother. I told her I loved her, that she'd done the right thing. Then I hung up and I called Chen back. The legal strategy sharpened fast. We had the revocation, which killed the sale, but we now also had evidence of a pattern. Derek had attempted to recruit Melissa into what was essentially a scheme to defraud the estate. 2 years of planning, the hard money loan in Boise, the urgent push to close the sale before I recovered consciousness. This was not a misunderstanding. This was intentional, premeditated, and multi-layered. Chen and I made the decision that afternoon. We would not just block the sale. We would pursue an abuse of power of attorney claim. In Idaho, where the property was located, POA abuse that constitutes financial elder exploitation could lead to enhanced damages. California, where Derek lived, had similar statutes. We would file in both jurisdictions if necessary. We would seek recovery of any property wrongfully transferred, though in this case the transfer had been halted before completion, plus damages for the legal costs, the emotional distress, and the breach of fiduciary duty. But there was a risk, a big one. The moment we went on the offensive, Derek would counterattack. He'd claim I was incompetent, that the stroke had impaired my judgment, that the new will was the product of paranoia or undue influence from Melissa. He'd use the very fact that I'd made the will without telling him as evidence that I was hiding things, that my mind wasn't right. He had a weapon for that fight. The durable POA from 2 years ago, the one I'd revoked, was not the only document Derek had collected during my stroke recovery. He'd also gotten my HIPAA releases. He had access to my medical records. He could selectively quote doctors' notes, cherry-pick moments of post-stroke confusion, assemble a portrait of a declining old man who didn't know what he was signing. I'd have to prove competence. I'd have to submit to psychiatric evaluations. I'd have to expose my medical history to a court, my entire private life, pried open by litigators working for my own son. Chen laid it out plainly. This is going to get ugly, Harlan. If we go after him for abuse of the POA, he'll claim this entire thing was an honest misunderstanding. He'll say he didn't know about the revocation. He'll say he was just trying to protect his father's assets from the cost of long-term care that might follow heart surgery. He'll play the grieving son, the reasonable son, the son who was only trying to do what he thought was best. And juries can be sympathetic to that. I thought about Alina, about the summers on the dock, about Derek as a boy learning to fish off that weathered planking, laughing when the line tangled, patient when the catch slipped away. The same boy who now tried to sell that dock to the highest bidder while I lay under a ventilator. No, I said, we go after him, full force. No mercy. I didn't want his money. I didn't want revenge. I wanted deterrence. I wanted a legal record so clear, so comprehensive, that no one in my family would ever try this again. Chen filed the civil complaint the next morning. Webb v. Webb, Maricopa County Superior Court, with parallel notifications to the title company in Idaho and the real estate brokerage that had listed the property without verifying the POA's validity. The complaint alleged breach of fiduciary duty, abuse of power of attorney, attempted fraudulent conveyance, and financial exploitation of an elder adult. It sought declaratory judgment that the power of attorney was revoked, a permanent injunction against any further transactions by Derek under the POA, compensatory damages for legal costs, and punitive damages. The filing hit the court docket at 9:15. By noon, a process server handed the papers to Derek at his hotel in Coeur d'Alene. What happened next was not the explosive confrontation I'd expected. Derek didn't call, he didn't storm the hospital, he went silent. For 6 hours, nothing. My attorneys waited. Melissa waited. I lay in my hospital bed, still draining fluids, still monitored, waiting for the other shoe to drop. And then, at 6:30 that evening, a new document appeared on the court docket. Derek's counter notice. He wasn't backing down. He'd retained a law firm, Morrison & Chase, specializing in probate litigation and elder law disputes. His filing read simply, Respondent Derek Webb contests the validity of the will executed June 2, 2023, on grounds of lack of testamentary capacity and undue influence by third parties. He demanded a full evidentiary hearing. He demanded my medical records. He demanded depositions of my physicians, my attorneys, my daughter. He was going to put my competence on trial, and because I was the one who'd filed first, I was the plaintiff. The burden of proof on the will's validity rested partly on me. I'd have to demonstrate not just that the will was properly executed, which was easy, but that I'd had the mental clarity to understand what I was signing. The irony was jagged. Derek had tried to steal my house, and now he was positioning himself as the protector of my legacy against my own confused judgment. I called Chen that night. How bad is this? His tone was measured. It's bad, but it's winnable. We have your physician's records from June showing full cognitive function. We have the notary's testimony that you were alert and oriented. We have the attorney's notes from your estate planning session. Derek's argument is weak, but it's the kind of weak that takes months and tens of thousands of dollars to defeat. You need to be prepared for a protracted fight. And a new complication, the buyer's group from California. They'd put down a significant earnest money deposit, and they'd missed their closing date because of our legal hold. Now they were threatening to sue for specific performance, to force the sale of the lake house under the original terms Derek had negotiated. Or failing that, for damages, their lost investment opportunity, their legal costs, their time. Their attorney's letter arrived at Chen's office the next morning, laying out a claim for $180,000. They argued that Derek, acting as my attorney in fact, had bound me to a valid contract. My revocation of the POA, they claimed, didn't erase the contract. It just meant Derek had screwed up, and they planned to hold someone responsible. If not Derek, then me. 3 fronts of war now. The title company seeking indemnification from any liability, the buyer seeking damages for a collapsed deal, and my own son, funded by the very hard money loan he'd taken to stay afloat, trying to have me declared incompetent so his version of the POA would be reinstated, the sale would go through, and he could finally escape his debts. I was 74 years old, 17 days out of open-heart surgery, and I was fighting for my home, my memory of my wife, and my reputation against an enemy who'd once called me dad. But there's something about surviving a quadruple bypass, something about waking up in the recovery room with your sternum wired together and your lungs full of fluid. You learn what you're capable of. You learn what you're willing to burn to stay alive. And I had one advantage that Derek didn't know about: the call I'd made to Melissa, her records, her documentation of his 2-year campaign to seize the lake house. That evidence was about to turn his counterattack into the legal equivalent of stepping on a landmine of his own planting. Melissa flew into Phoenix the next morning. She came straight from the airport to my hospital room, a thick binder tucked under her arm. No hug first, no small talk. She sat in the chair beside my bed, opened the binder, and spread 3 years of evidence across my blanket. I'd saved everything, Dad. Emails, texts, voice messages. I didn't know why I was keeping them. I just knew something was wrong. She pressed play on her phone. Derek's voice filled the room. The recording was 2 years old, from the weeks after my stroke. "Melissa, you're being unreasonable. Dad needs this trust. The lake house is a liability. If he goes into long-term care, the state could take it. I'm trying to protect all of us." A pause, then harder. "You don't understand estate law. You're going to ruin everything because you're emotional." I'd never heard that tone from my son. Cold, patronizing, strategic. Melissa had held her ground then, and she'd held the evidence since. Chen arrived an hour later, along with his paralegal, a scanner, and a portable printer. My hospital room became a war room. Melissa walked us through every document. The timeline that emerged was damning. Derek's first contact with a Coeur d'Alene real estate broker dated back 19 months, not after my surgery, not after my stroke, but 6 months before the new will. He'd requested a confidential market analysis of the lake house. The broker's email had asked, "Do you have authority to represent the owner?" Derek's reply, "I have full power of attorney. My father is elderly and trusts me to handle his affairs." Elderly, trusts me, words that would become a liability. Chen kept digging. He subpoenaed the brokerage's records, then the title companies, then the hard money lender in Boise. The picture expanded. Derek had been in financial free fall for 4 years. The Bend development failure was worse than I'd imagined. Not just $700,000 in construction loans, but an additional $250,000 owed to subcontractors who'd sued. He'd settled 5 lawsuits in the past 3 years. His Portland home had 2 mortgages and a home equity line of credit fully drawn. His credit cards were maxed. The hard money loan from Boise wasn't his first, it was his 4th. He'd been rolling over short-term debt at predatory rates for 18 months, desperately waiting for something to break. And then the real bombshell landed. Chen subpoenaed the buyer's group from California and discovered they weren't strangers. The investment group's managing partner was a man named Victor Sandoval. Sandoval and Derek had overlapped in commercial real estate circles in Portland, more than overlapped. They'd co-invested in a property in Bend 4 years earlier, the same property that had failed, the same failure that had triggered Derek's initial collapse. They were business partners, former partners, and now Sandoval was the buyer of my lake house. At $1.2 million, a price Chen's appraiser later confirmed was $400,000 below market. The math was brutal. Victor Sandoval buys my lake house at a steep discount. Derek gets an undisclosed kickback or, at minimum, a payoff that clears his debts to Sandoval. Everyone wins, except me, except Elena's memory, except the truth. This wasn't a desperate son making a bad decision. This was a conspiracy. 2 men who'd lost money together, finding a way to recover it by looting an elderly man's estate while he lay on an operating table. Chen expanded the complaint that afternoon, added Sandoval as a co-defendant, added counts of civil conspiracy and intentional interference with inheritance expectancy. The filing made the Boise newspaper, then the Coeur d'Alene Press, then the Phoenix Business Journal. Derek's counterclaim, the one challenging my mental competence, now looked like what it was, a cover fire. He'd claimed I was confused and paranoid. The email trail showed he'd been plotting the sale before my new will existed, before my confusion could possibly have been a factor. But here's where it gets worse, because during discovery, Chen's forensic accountant found something else. In the 2 weeks between my hospital admission and the day Chen killed the closing, Derek hadn't only attempted to sell the lake house. He'd used the power of attorney to access a brokerage account I'd forgotten about, an old Charles Schwab account worth about $280,000 that I'd opened years ago for charitable giving. Derek had liquidated it, transferred the money to an account in Portland, and spent it. most of it anyway. $37,000 remained, the rest gone. Paid to creditors, to Sandoval's hard money lender, to credit cards, to his mortgage. $243,000 vanished while I was on a ventilator. I learned this at 7 in the evening, still in my hospital bed, watching the sunset over Phoenix through a window I couldn't open. The fury that rose in my chest was physical, painful. The surgical incisions ached. The monitors beeped faster. A nurse came in, checked my vitals, gave me something in the IV that softened the edges. I let the medication work, but I didn't let it extinguish the clarity. The Schwab account wasn't the lake house, but it was the key to Derek's legal destruction. Because the POA I'd revoked, the one he used, had a specific clause: the agent may not make gifts or transfer assets to himself or for his own benefit except as specifically authorized in writing. Derek hadn't gotten specific authorization. He'd just taken. The liquidation of the brokerage account was self-dealing of the most straightforward kind. Breach of fiduciary duty, documented in bank records that couldn't be disputed, couldn't be explained away. Even if his challenge to my will succeeded, even if a court somehow found me incompetent and reinstated the old POA, the asset transfer to his personal account was still illegal under the very document he was trying to enforce. Derek had hanged himself with his own rope, and he didn't know it yet. Chen scheduled the deposition for the following week. I'd been discharged from the hospital by then, recovering at home in Phoenix with a visiting nurse and Melissa checking in daily. I was weak. I couldn't walk more than 100 feet without resting, but I was compos mentis, alert, oriented, and angry. My physician wrote a letter confirming I was fit to testify. My cardiologist signed off. My neurologist performed a full cognitive assessment and scored me in the 85th percentile for my age. All of this went into the record. Derek wanted to put my competence on trial. Fine, I'd bring the evidence. The deposition took place in Chen's conference room, floor-to-ceiling windows overlooking Camelback Mountain. I sat at the head of the table, a glass of water at my elbow, my medical records stacked in a binder beside Chen. Derek arrived with his attorneys, two of them Morrison and Chase, the probate litigation specialists. He looked thinner than I remembered, dark circles under his eyes. The confident real estate developer, now a man whose entire scaffolding of lies was collapsing. He wouldn't look at me, not once. Sat across the table, stared at his hands, answered questions in a voice that sounded swallowed. Morrison did most of the talking, objecting when Chen's questions cut too close, redirecting, trying to paint the picture of a confused old man manipulated by his daughter Melissa. It didn't work. Chen was methodical. He started with the timeline, the stroke, the original POA, the 2 years of silence, then the new will. Then the emails with the broker, sent 6 months after I'd revoked his authority, when Derek had no legal right to even inquire about the property. Then he played the recording, Melissa's phone, Derek's voice, 2 years old, lecturing his sister about estate law, dismissing her concerns, demanding she sign away her inheritance. The conference room fell silent. Derek's attorneys exchanged glances, a brief flicker of professional alarm. Then Chen placed the Schwab records on the table. You transferred $243,000 from your father's brokerage account to your own personal account. Is that correct? Objection moved to strike, but Derek's face had gone gray. The deposition lasted 3 hours. By the end, Derek's counter-narrative was in pieces. He hadn't just failed to prove my incompetence, he'd demonstrated his own calculated, long-running fraud. The Schwab transfers were indefensible. The Sandoval connection was documented. The emails with the broker predated my new will, proving he'd viewed the POA as a permanent license to appropriate assets, not a temporary safeguard for medical emergencies. 2 days after the deposition, Morrison and Chase withdrew as Derek's counsel. The court filing cited irreconcilable differences. Everyone in legal circles knew what that meant. They'd seen the evidence and realized their client was going to lose spectacularly and probably be referred for criminal investigation. Derek was suddenly unrepresented, alone. His counterclaim still technically on the docket, but any competent judge would now view it as frivolous. I expected a call from my son. Apology maybe, desperation certainly. It didn't come. Instead, a letter arrived at Chen's office the next week. Handwritten, 4 pages. Derek's cramped script, covering everything from childhood grievances to accusations about Elena favoring Melissa, to a final, stunning demand. If I dropped the lawsuit and restored the lake house to a trust he could manage, he'd forgive me for destroying his reputation. He'd also return what remained of the Schwab money, the $37,000, and we could pretend none of this ever happened. I read the letter 3 times. Forgive me for exposing his crime, for protecting his mother's legacy, for refusing to be looted while unconscious. I gave the letter to Chen. He filed it with the court as an exhibit, proof of Derek's state of mind, proof of the ongoing effort to extract concessions even after the fraud was exposed. The judge, a woman named Elena Vasquez, who'd handled elder exploitation cases for 15 years, scheduled a status conference for the following month. Chen told me to expect a preliminary ruling on the lake house. He also warned me the buyer's lawsuit was still alive. Sandoval's attorneys were arguing they'd acted in good faith, that they had no way of knowing the POA was revoked, and that I, as the principal who'd originally granted the authority, bore responsibility for their losses. That claim had some legal traction. If an agent acts under color of apparent authority and a third party reasonably relies on that authority, the principal can be bound. But there was a problem with their argument. The title company had received the revocation before the closing happened. Sandoval's earnest money was still in escrow. It could be returned. Their damages were largely legal fees and lost opportunity, not actual property loss. And given the newly revealed connection between Sandoval and Derek, their good faith defense was looking porous. If Chen could prove they knew or should have known the POA was questionable, the below-market price, the rush to close, the prior business relationship, the entire edifice would crumble. The status conference approached. I had recovered enough to walk without assistance now. The cardiac rehab was working. I'd started driving again. Melissa had taken leave from her job to stay with me part-time, and together we'd begun the process of inventorying everything Derek had touched, accounts, properties, documents, to ensure nothing else had been plundered. But the most important piece of evidence hadn't been revealed yet. Not the emails, not the Schwab records, not the Sandoval connection. It was a 30-minute video recording made 6 months before my surgery in Robert Chen's office, the same day I signed the new will. I had insisted on it. Chen had set up a camera, sat across from me, and asked me a series of questions under oath. Why I was revoking the prior POA, what I understood about my assets, what I intended for the lake house, whether I was acting freely and with full mental capacity. The video was sealed, notarized, time-stamped, and stored in Chen's safe. Derek didn't know it existed. His attorneys, before they withdrew, hadn't discovered it, and Judge Vasquez was about to see every frame. This was the evidence that would end not just the lawsuit, but any shadow of doubt about who I was and what I'd decided. The only question left was whether Derek would still be in the courtroom to witness his own name being struck from the last page of my story. Judge Vasquez gavelled the courtroom to order on the 3rd Monday of September. The gallery was sparse, Melissa in the front row, a reporter from the Phoenix Business Journal, a few law students who'd followed the docket. Derek sat alone at the respondent's table, no attorney. His former counsel had withdrawn. He'd filed a motion to represent himself, which the judge had accepted with a warning he clearly didn't fully understand. He wore a suit that hung loose on his frame. The circles under his eyes had deepened into bruises. I was seated beside Chen at the petitioner's table, a small oxygen canister discreetly beside my chair. My recovery was ahead of schedule, but I wasn't yet the man who'd built a cabin with his own hands. I was, however, the man who'd signed that new will, and the video was about to prove it. Judge Vasquez began with preliminary rulings. She'd reviewed the evidence submitted, the timeline, the emails, the Schwab records, the Sandoval connection. She spoke in a measured tone that gave nothing away. This matter involves serious allegations of elder financial exploitation, breach of fiduciary duty, and abuse of power of attorney. The core question is whether the power of attorney relied upon by Mr. Derek Webb was valid at the time of the attempted property transfer. Resolving that question requires determining whether the June 2, 2023 will and its revocation language were executed by a competent testator. She looked at me. Mr. Harlan Webb, your attorneys have submitted a video recording as evidence of testamentary capacity. I'll review it now. Chen cued the video on the courtroom display. The lights dimmed. My own face appeared on the screen, 6 months younger, no surgical scars, sitting in the same leather chair in Chen's office where this entire defense had been conceived. The questions began, Chen's voice off camera. Please state your full name and today's date. Harlan Everett Webb, June 2nd, 2023. Do you understand that you are being recorded for the purpose of establishing your mental clarity and intentions regarding your estate? I do. I requested this recording myself. Why are you revoking all prior powers of attorney, including the durable power of attorney you executed on March 14th, 2022? My on-screen self paused. I remembered that pause. I'd been choosing words that would survive a courtroom. Because I have reason to believe that the power of attorney I granted my son Derek during my stroke recovery has become a risk to my estate. I've seen patterns of financial pressure in his life that concern me. He has approached my daughter Melissa about transferring assets into a trust he would control. He has made inquiries about the market value of my lake house in Coeur d'Alene without my knowledge or consent. I am not incapacitated. I am not confused. I am acting freely and with full understanding of what I'm doing. The prior power of attorney is revoked. The new will speaks for itself. What are your intentions for the lake house property on Lake Coeur d'Alene? It passes to a professional trustee upon my death. The trustee is instructed to maintain it as a family asset for the use and enjoyment of my daughter Melissa and her children. My son Derek is explicitly excluded from any control over the property. This is not punishment. This is protection. I love my son, but I do not trust him with this asset, not anymore. The video continued for another 15 minutes, covering every asset, every account, every question a probate court might ask. I watched Derek's face as it played. He didn't move. His eyes stayed fixed on the screen. When it ended, the courtroom lights came up. Judge Vasquez removed her glasses and addressed him directly. Mr. Derek Webb, you filed a counterclaim alleging lack of testamentary capacity and undue influence. I have now seen extensive evidence regarding your father's state of mind at the time of the will's execution. Do you have any evidence to present that contradicts what I've just viewed? Derek stood. His hands were shaking, but his voice was steady, the wrong kind of steady, the brittle calm of a man with nothing left to lose. My father was manipulated by my sister. She's been trying to turn him against me for years. That video is a performance. He doesn't understand the consequences of what he's doing. He's isolating himself from the one person who actually tried to help him. The judge let the silence stretch after he sat back down. Then she spoke. Mr. Webb, the court has also reviewed the forensic accounting of the Schwab brokerage account. $243,000 transferred from your father's account to your personal account in the 2 weeks following his quadruple bypass surgery. Do you deny making these transfers? It was for his medical expenses. I was the power of attorney. I had authority. Did you have written authorization to transfer assets to yourself for your own benefit, as required by the very power of attorney document you're now trying to enforce? Derek didn't answer. He couldn't. The document was clear. The transfers were self-dealing. Even if the POA had still been valid, which it wasn't, the transfers would have violated its terms. Judge Vasquez issued her ruling from the bench. It took 40 minutes. The substance was this. The June 2nd, 2023 will was valid in every respect. The durable power of attorney executed March 14th, 2022 was explicitly and effectively revoked. All actions taken by Derek Webb under that revoked authority were void ab initio, void from the beginning. The attempted sale of the lake house was nullified. The earnest money in escrow was to be returned to the buyer group. The title company was absolved of liability for acting in reliance on an apparently valid POA, given that they halted the closing immediately upon receiving notice of revocation. Then she turned to the Schwab money. The evidence establishes that Mr. Derek Webb used the revoked power of attorney to access and liquidate his father's brokerage account, transferring the proceeds to his own account. This constitutes breach of fiduciary duty, self-dealing, and financial exploitation of an elder adult under Arizona revised statutes. The court orders full restitution of the $243,412 plus statutory interest. In addition, because the defendant acted with reckless disregard for his fiduciary obligations, the court awards enhanced damages in the amount of $100,000 payable to the plaintiff. She looked at me, then at Derek. Mr. Derek Webb, the court is also referring this matter to the Maricopa County Attorney's Office for review of potential criminal charges, including exploitation of a vulnerable adult and fraudulent conveyance. You have 30 days to begin restitution payments. Failure to comply will result in contempt proceedings and potential asset seizure. The gavel came down. It was over. Derek stood motionless as the courtroom emptied. I remained seated for a minute, letting Chen's hand on my shoulder ground me. Melissa was crying quietly in the gallery. She'd done everything right, preserved every piece of evidence, endured her brother's manipulation, and now she was the named beneficiary of the lake house her mother had loved. Justice, in its cold legal way, had been served. We walked out into the September sun. Phoenix was beginning to cool toward autumn, the brutal summer finally releasing its grip. A reporter approached. I answered 3 questions. No, I didn't hate my son. Yes, I would pursue restitution. Yes, I believed the system had worked. Then Chen guided me to the car and I went home. The aftermath unfolded over the following months. Sandoval's lawsuit against me was dropped within 2 weeks. The title company had refunded his earnest money, and his attorneys realized that pursuing the claim risked exposing his prior business relationship with Derek, a fact that would demolish any good-faith reliance argument. The California Investment Group took a quiet loss on their legal fees and walked away. Derek filed for bankruptcy in December. The restitution order was non-dischargeable. Bankruptcy couldn't erase it. His Portland house went to the bank. His remaining assets were liquidated. The hard money lenders in Boise got pennies on the dollar. He moved, I was told, into a rented room in Gresham and took a job managing a storage facility. He didn't contact me. I didn't reach out. The Maricopa County Attorney's Office did review the referral. After 6 months, they declined to prosecute, citing my statement that I didn't wish to pursue criminal charges and the fact that Derek had no prior criminal history. I was simultaneously relieved and haunted. He was my son. The legal victory had been necessary. Prison was something else. I returned to the lake house the following June. Melissa came with me. We drove up from Phoenix, 12 hours on the interstate, then the winding roads through the pines, the sudden glitter of the lake through the trees. The cabin was exactly as I'd left it before the surgery, weathered, quiet, standing in its clearing like it had been waiting. The dock was solid under my feet. The loons were there, calling across the water. Elena's garden had bloomed without her again, columbine and lupin, and the wild roses she'd planted the first summer. I stood at the railing and looked out at the same view I'd seen 1,000 times with her beside me. And then I noticed something, a brass plaque mounted on the dock's end post. I hadn't put it there. Melissa came up beside me. I had it made, she said. I hope you don't mind. I leaned down to read it. The inscription was simple. For Elena Webb, she loved this water. She loved this light. She loved this family. May those who come here remember what matters. Below it, a single date, the day she died. I stood there for a long time. The lake glittered. The breeze stirred the pines. The house behind me was secure, legally, financially, permanently, not just for my lifetime, but for generations after. Derek's name was nowhere in the trust documents, the will, or the deed. But at that moment, standing on the dock she'd loved, I realized the victory wasn't about him at all. It was about her. It was about the 30 summers we'd shared, the garden she'd planted, the loons she'd listened to in the morning quiet. I hadn't just saved a property. I'd preserved the one place where her presence still felt real. Justice isn't always revenge. Sometimes it's simply the refusal to let someone erase what you built. Sometimes it's a brass plaque on a dock, a new will in a safety deposit box, and the certainty that the next generation will understand the difference between taking and receiving. Derek had tried to take. The law had stopped him. The lake house remained. And in the end, that was everything. That summer, I stayed at the lake house for 6 weeks, the longest stretch since Alina died. I woke early, made coffee on the same stove I'd installed 30 years ago, walked the dock in the morning quiet. The loons were still there. The columbine she'd planted still bloomed. The water still caught the sunset in shades of orange and pink that made my chest ache in ways the surgeons hadn't touched. I thought often about what almost happened. If I hadn't updated that will, if Chen hadn't been in his office that morning, if Melissa hadn't saved every email, any one of those threads breaks, and the lake house belongs to an investment group from California, and Alina's garden is someone else's landscaping project. The thing about power of attorney abuse is that it almost never announces itself. It comes wearing the face of the person you're supposed to trust most. Nationwide, an estimated 1/3 of all POA abuse cases involve a family member. The average annual loss to an older victim of financial exploitation is more than $34,000. And in my case, the number would have been 1.2 million, plus the Schwab account, plus the memory of every summer Alina and I spent building this place. Derek had been my son. He'd sat on this dock as a boy, learning to cast a fishing line. He'd helped me stain these deck boards one August when he was 12, complaining the whole time about the heat. I loved him. I still love him, and he tried to destroy me. That's the complexity nobody warns you about. Elder financial abuse isn't always a stranger on the phone with a scam. Sometimes it's the person who knows your signature, who has your medical records, who shows up at the hospital looking like the attentive son while emptying your brokerage account in another tab of his browser. The legal system worked in my case. The will was honored, the restitution was ordered, the house was saved. But for every case that reaches a courtroom, there are hundreds that never do. Victims too embarrassed to report, families too fractured to fight, assets too tangled to recover. If you take one thing from this story, let it be this: a power of attorney is not a family favor. It is a legal weapon. It grants another person the authority to sell your home, drain your accounts, and rewrite your legacy while you lie in a hospital bed. If you're going to grant one, grant it carefully. Limit its scope. Require reporting. Appoint co-agents. And update your estate documents regularly. Not once, not casually, but with the same vigilance you'd apply to any other financial decision that could destroy everything you've built. And if you're the adult child of an nagging parent, remember, your inheritance is not your money. Your parents' assets are not your emergency fund. The person lying in that hospital bed trusted you to protect them. If you can't separate their interest from your own, you shouldn't have the keys to their kingdom. Derek learned that lesson in a courtroom. He's paying restitution he can't afford and living in a rented room he'll never own. I didn't want that for my son. But I wanted even less to be the father who let himself be erased. The lake house is safe now. The trust is ironclad. Melissa and her children will inherit it someday without legal challenge, without the taint of what Derek tried to do. I've spent the last year restoring what I almost lost, not just the property but the peace. Mornings on the dock, evenings with a book, the sound of wind through pines that don't know anything about courtrooms or lawsuits or betrayal. There's a lesson in that too. Justice isn't just winning. It's waking up in the morning without the weight of what you should have done pressing on your chest. It's walking down to the dock and knowing that the water in front of you belongs to your family, not to the predators who tried to take it. It's the quiet that comes after the fight, when the legal documents are filed and the final ruling is in your favor, and all that's left is the life you protected and the memory of the people who helped you build it. Alina never got to see this ending, but I think, somehow, she'd be satisfied with it. Not with the money or the victory, with the fact that I finally saw our son clearly and still found a way to love what mattered. If this story resonated with you, please like this video, subscribe to the channel, and share your own experiences in the comments. To watch the next story, click on the box on the left. Thank you for listening.